Hi, this is Reen. Sounds like green. I'm a Minnesota realtor helping families get through probate with more money and less stress. And today I'm joined by Minnesota attorney Rebecca Bell from RB Legal. And Rebecca brings over 30 years of experience, and her motto is listen first, solve second, and care always. And her firm is known for personalized service, educational resources, and a client-centered approach, which results in a remarkable return of many of her clients and also referrals. Rebecca, welcome to the Probate Help Desk podcast, and please tell us a little bit about your services and what drew you into this line of work.
Sure. Thank you. I love taking care of people. I grew up in the hospitality industry. My first career was working in hotels. And that's all about welcoming people and taking care of them and making sure they're provided for. And so when I went to law school and I started my practice, um, that was really the method I went with.
Mm.
It's what I knew, it's what I felt comfortable with. And I always feel a little embarrassed. I'm not like those TV attorneys that are dashing off to court or doing this. Um, no, people cry in our office. People have concerns. People are worried about things. And our job is to take care of them
Mhm.
and give them peace of mind through the work that we do. So it's personal to me, and it's personal that people have access to information and knowledge so that they can learn how to make good decisions.
Absolutely. And one of the things that I mentioned to you before we started is on your website, you have so much good information for personal representatives and family members. I've looked at a lot of attorney websites, and yours has more information than I found on any of the others. And I was really impressed with that. So I really appreciate your commitment to education.
Oh, thank you. So, if we want, we can just talk a little bit about probate in general. There's two types of post-death administration: probate, and the other is a trust administration.
Mhm.
So depending on what sort of estate planning vehicle you have, which would be a will or a trust, or other areas that you might have um, to deal with real estate. In the state of Minnesota, and I can only speak for Minnesota, I'm only licensed in Minnesota. So uh, my disclaimer is I'm a Minnesota licensed attorney. I am only referencing Minnesota law, and I am not providing legal advice to you. We do not have a attorney-client relationship until we would both have a document in writing. This is merely informative. So pardon my attorney part there.
I
But
appreciate that. I really do.
so in the state of Minnesota, you end up in probate if you own real estate in your name, or if you have $75,000 of assets with or more without a beneficiary designation. So either one of those or both of those
Hmm.
will end up in probate. So what does that mean for real estate? If you have a piece of property, let's say you and your spouse own a home, and you are on the deed as joint with the right of survivorship.
Hmm.
That means the last person standing. So if your spouse passes away, you get the whole thing. If, however, somewhere along the line, the deed has been drafted where it does not have those magic words, joint owners, joint with the right of survivorship, you and your spouse each own an undivided 1/2 interest in the property. So what does that mean? If you are And in that situation, that means you are tenants in common. It's another legal term, tenants in common. You each own 1/2 of the real estate. If one of you passes away, you may end up only owning 1/2,
Mhm.
and that other half may go to your spouse's children, children from a previous marriage, other complications,
Yeah.
and now you have a mess
Yes.
because you think you've owned a whole house, but you haven't. And then you find out when you're ready to sell the house.
Hmm.
Well, now there's a whole lot of work to be done because now you're in a probate situation. And that sale may fritter away.
Absolutely. And that's a question that comes up on the real estate side a lot, even for people who may be buying their first home and they're asked if they want to take title as joint tenants or tenants in common. And then maybe someone who's uninformed will say, well, it doesn't matter. You can figure it out later. You can always change it. And guess what? Guess how many times they change it?
You get busy, right? Life gets
Right.
busy.
Yep. Yep.
You
And
know,
then 30 years. Oh, I'm sorry. Go ahead.
or you own a house um prior to being married,
Hmm.
and that's set up as tenants in common. Now you
Yep.
get married, you need to make a change if you want it to be
Absolutely.
joint.
And on with some of the work that I do, I see it come up a lot, especially in situations where there may have been a divorce someplace throughout the person's life, and then there might be a step parent involved and stepchildren, and right, it just sprawls out into so many different situations.
Or, we had a situation years ago with 3 siblings, and then one of the siblings predeceased the dad,
Mm,
and his share went to his wife, and her share went to her son, who none of them even knew
hmm.
because it was a later in life marriage. Dad passes away, and we have 2 siblings and a random stranger virtually
Yeah.
owning a house together.
Yes. Wow.
Yeah,
So in that situation, was it unraveled through the probate
it was
process?
unraveled through probate. So when I
Okay.
say we don't do court, we don't do suing and litigation in that sense. We do probate court, um, which is a little different, I would say.
I'd like to kind of ask a question about one more topic because this is something that comes up a lot in our groups is I work with a lot of people who assume that if they have a will that they can avoid probate. And sometimes if they're already living in the house, they might not start probate because they live in the house. The will says that the house goes to them and they just think something magical happens and it's their house. And then maybe they'll come around 5, 10 years later when they want to sell the house and realize that someone else has an interest in the property. Could you speak a little bit, especially in Minnesota, about the need to go through probate even if you have a will and kind of the difference of intestate and testate?
Sure. So again, if you have a will in Minnesota, you pass away owning real estate, at some point, that is going to be a probate matter. Probates can be, I would say, a rule of thumb is a probate is far more expensive than a good estate plan.
100%.
And a good estate plan isn't going to be, in my opinion, a form that you filled out.
Right.
Minnesota doesn't acknowledge handwritten wills. Minnesota doesn't acknowledge common law marriage.
Mm-hmm.
All of things that some people think, well, we've lived together for 30 years. I call her my spouse, I call her my whatever. Yes, but
Yeah.
what does it say on the piece of paper that is filed in the county, not the taxpayer? Because like anyone that collects money, if you want to send them money, the Department of Revenue will take your money to cover the taxes. It's not what it says on the tax statement. It's what it says on the deed.
Absolutely, absolutely. And you're starting to segue into one of the questions that we have, and that is real estate is often a family's largest asset. And so you've given us a couple of reasons why it's important to do some estate planning, but just expound upon that a bit and talk about why it's so important for people to do estate planning, especially when there's real estate involved.
So I would say estate planning, whether you have a will or trust, it doesn't mean you are whatever, you're a Kardashian, you have a ton of money, whatever the recent terminology, whoever it is, right? It simply means you own things. It doesn't have to be a lot of things.
Mm-hmm.
Um, so a will, you can leave your home to someone in a will, but it will end up in probate.
Right. Right.
Absolutely. Now, there is a document called a transfer on death deed, a TODD.
Mm-hmm.
Transfer on death deed is like a beneficiary designation on your house. Now, some people, let's say I have 4 kids and I want to list, I'm going to treat them all equally. I'm going to list all 4 kids on that transfer on death deed. That is not recommended at this point under Minnesota law. Minnesota law requires, and you know this, Rain, 1 to buy, 2 to sell.
Yep. Yep.
So now you have your 4 children and their 4 spouses, all that have to agree and sign on the dotted line. Plus, if you have something that goes through probate, now we're transferring from talking about a transfer on death deed, I'm jumping back to a probate. But with a probate process, we're subject to the court's calendar. Everything that we file with the court is public information. You go online, pull it up, you can look at it. You can order copies. So it's public information. And at the end of the day, it can take maybe 3 months to get you officially appointed by the court. Again, depending on the court calendar and a variety of other things. But it can take up to 3 months, maybe longer, maybe shorter, but definitely maybe longer
Mm-hmm.
to get you appointed as the person who can officially handle real estate transactions.
Yes.
The house can't be sold until you hit that point.
That is a fantastic, I'm so glad you said that because one of the things that I run into as a realtor who understands probate, I know that they need to have their letters or court authorization before they could sell the house. Sometimes, I'll be dealing with people maybe on the other side of the transaction who don't understand that. And again, they think they have the will and they might even send the title company or me a copy of the, I'm like, I don't need to see a copy of the will. I need the letters from the court. Um, but they'll make that assumption and then they'll get to closing, or maybe they worked with a real estate agent who doesn't understand probate process, or even very simply that letters are required to complete the transaction. And then they'll get to closing, and title company will say, well, where are the letters of administration? And they'll say, what are you talking about? Right? Letters of administration, certificate of medical clearance, those are the two things that seem to pop up a lot when dealing with agents who don't understand the process. Um, and so I'm really glad you said that. Like, it is absolutely important to start the probate process so that you can work with an agent like me or your attorney or someone to complete complete the process in a timely manner. Because I've seen people lose buyers because they weren't
Oh,
prepared, and then the
absolutely.
buyer
Absolutely.
walks away, market changes, and Minnesota gets cold. You have to
Right.
wait another year.
Right. And I can't tell the court that that hot summer market is coming up. They need to hurry it up.
Hmm.
Court doesn't listen to me for that.
Right.
So it just, it is. Um, and then let's talk a little further about selling a house from an estate.
Hmm.
If this is the house of a parent, an aunt, an uncle, uh, if you've never lived in the house, there are
Hmm.
things you may not know. And you know where I'm
Can
going with
can
this,
I clap?
Rain.
Can I clap? I'm
You can
so
clap. Go ahead and tell them what they need to know here.
well. I actually debate this with a lot of other realtors. And for me, it comes up in the context of my often I'll make the recommendation that they don't fix up the house in order to sell it. And part of the reason is because I want the liability protection for the estate on the disclosures. And then also I don't want to impact the PR's deed, right? Like I want to keep it really clean. I want them to be able to sell as is and not have any knowledge of any material uh, claims, right?
And you look at that as is addendum,
Mm-hmm.
make sure that's there.
Absolutely. Absolutely. And
Because you just can't know if you haven't lived there. And
right.
yes, that may have been your mom and you may have been there 3 or 4 times a week, but that's a liability
Mm-hmm.
on your shoulders. If you're saying that the sump pump works and there's never water in the lower level and the roof never leaks and there's never been, and they find out later.
Yeah. Well, and then what complicates it even more for some clients is that someone in the family will say, well, we really should remodel the kitchen because we'll be able to get an extra $20,000, right? We can't sell it the way it is. We need to do that remodel. Well, as soon as you start making those repairs, you now have material knowledge of some of the defects of the property, and you can lose some of that liability or at least put it at risk. And it's
And I think I don't really have a comment on whether people remodel or not, or what choices they make there, as long as in the legal transactions in the sale, they're protected and you make
abs
those items clear.
absolutely. Well, we could do a whole nother podcast on that topic. I don't want to go into the net sheets today,
There we go.
but I do that's one of the things I really like to point out for probate families is it is possible for us to put the house on the market as is. Um, have you get extra, in some cases, extra protection from liability depending on what your attorney recommends and if they agree. And a lot of times we can net the family more money than if they actually do put money into the house and do the remodel. It depends on the house and market conditions, those kinds of things, but people are often amazed at how much money they can save by selling as is and not doing the repairs. And most agents will not tell them that in Minnesota. So
That's your job on that end.
that's my job, absolutely. Um, excuse me. Let me get to some of the common real estate challenges that you see. You talked a little bit about this, but could you talk a little bit more about what happens when some of these properties have multiple owners or complex ownership structures? In fact, we're going to talk about a question that came in from our Facebook group in a little bit, where they had a situation that was similar, but they didn't know if the person who was deceased, he owned the house with several partners, but they didn't know if the business was in a legal entity like an LLC or if they were just um, tenants in common. They didn't know, or joint tenant. But like no, they didn't know what the
Right.
situation was. Could you talk a little bit more about what happens when there are multiple owners in a probate situation?
So with multiple owners, again, we have to determine who's on that deed that's filed with the county. And then we have to find them. And if they're
Hmm.
an entity, Is it still valid in the state of Minnesota? Are the partners still partners? Are the people involved still involved? And that takes a lot of time and a lot of back and forth, right? We work with our clients. So what do you remember about Aunt Hilda? You
Mhm.
see Aunt Hilda's name here. Did Aunt Hilda have any kids?
Yeah.
I would say the most complicated heirship issue that we had in a matter was where there was no one surviving in the current generation.
Mm-hmm.
We went all the way back to great grandparents.
Mm-hmm.
Now we're in the 1800s where a lot of women died in childbirth. And we have great grandpa with three different wives, each of whom passed in child, or at least the first two passed in childbirth, each having at least one or two kids, and tracking it all the way back because there was nobody else before that that qualified. Now,
Mm-hmm.
that's the exception, not the rule. But you might not know that until you're in the middle of things.
Absolutely. I worked on a Minnesota case like that as well, where the person passed away and the primary executor in the will passed away and the backup also passed away. And so we weren't able to identify any living relatives. And so same thing, I worked with the attorney and we had to go back and do the research and then, start with the great grandparents and find out who was still alive. And I learned a lot working on that case, but I would not wish that upon any family, especially when they can just take care of it up front.
Right. And so that is the ideal pitch for don't do your estate planning documents and think they're done for the rest of your life.
Mm-hmm.
So we often have people come in with an estate planning document and they look at it and they go, well, why did I have Marge in charge? I don't even talk to her anymore. We got mad at each other in 1973.
Mm-hmm.
We haven't spoken since. Or they've passed away, or any of those situations. So a couple of things to remember. If you have any type, if you have a wilderness or a trust, either one, you want to change somebody's name, don't cross their name out and write on the document. Minnesota has very strict signing requirements so that what you can actually have done is make the estate planning document invalid because you've written on it. Now
Mm.
nobody knows what you want. I mean, I've seen it. Cross out the name, then initial it, put the date that you initialed it. It doesn't count for Minnesota's signing requirements, their legal requirements. So if you have we always say every 3 to 5 years,
Mm.
um, or death, disability, divorce, you win the lottery,
Mm-hmm.
you get a promotion in a job, you move out of state, you want your estate planning documents to be valid in the state where you live. Or you move into Minnesota and you have documents from Georgia.
So the follow-up question I have then on that topic is in Minnesota, if the so I'd imagine that scenario they think they have a will. Someone had made a change manually, right? And they'll probably even say, and I had a witness too, right? They always think that's the golden ticket. So they had a witness, they wrote on the will, someone files for probate the way they're supposed to, and the judge looks at the will, and I assume the judge would say then it's not valid. Then at that point, do they just instruct the personal representative to follow state statute, or would they do something else?
If you're working with an attorney,
Mm-hmm.
or at least I can say if you're working with us, we'll try and get all of that. We'll work with you in the courts to try and get some of that resolved before you're right there in front.
Oh, nice. Okay.
So you need, there's formal probate, informal probate, supervised probate, unsupervised probate. And the most expensive probate of all, in what I see, is if you have no estate planning documents at all,
Mm-hmm.
or your estate is insolvent.
Mm-hmm.
So those with the least money costs the most to fix. I that I didn't make that. That just happens. So
Absolutely.
the thing to look at is keep your estate planning documents current. So there didn't used to be things like digital assets,
Mm.
like access to your reward points,
Oh,
your
yes.
your Facebook account, all of those things. Those are relatively newer laws that might not have existed when you had your plan drafted.
Absolutely.
Access to Bitcoin. There's a lot of things.
Wow.
Bitcoin
Wow.
didn't used to be a thing, right?
Right. Right. Yeah. So in a situation like that with digital assets, then are you encouraging families to document some of that information right in the will or the trust? And when I say some of that information, I'm talking about like accounts and usernames and passwords. Like how far do
No,
you
no, no,
go?
no, no, no.
No.
No, no,
Okay.
no. You do not want that in that legal document. You need the information for access. Your family will need that information. You don't want that in a legal document.
Okay. So in the legal document, what are you just
You're
referencing that
addressing
asset?
the
That asset?
existence of it.
Okay. Okay. And designating who should get it or how it should be dispersed.
Yep.
I understand. Okay. Wow. Yeah, my head almost exploded when I started thinking about all the different possibilities with digital assets.
Hey,
And
I got somebody a trip to Arizona just based on getting her husband's frequent flyer miles.
oh wow. Oh wow.
Like, I've lost all of that. I'm like, nope, no, you haven't.
Hmm. We've been talking about the impact of real estate on probate. What what other what are some other tips that you think that our listeners should be aware of when it comes to impact of I'm sorry, the impact of real estate on probate or the estate plan?
There's simple things. Uh, if if you're selling something out of a trust, it's a trustee's deed, not a warranty deed, not a quitclaim deed. So there's different deeds that address different things. And for the most part, knowing what you have, and
Hmm.
you may have a plan for it today, but what if that changes? You can
Hmm.
change your legal documents. I always say done is better than perfect, because that perfect paralysis keeps you from getting things done.
Hmm.
Then it sets you up for one of those challenging situations because things are out of date, or you don't know, or you assume that the house is yours, like your example, Reen.
Yes, absolutely. And I think I just to recap what I think I heard you say, then you would recommend a family update their either their will or their trust every 3 to 5 years. So either a major change or at least make sure you're in that 3 to 5 year window if you think nothing has changed.
It's worth revisiting,
Okay.
right? If it's
Hmm.
3 years and there's been absolutely no changes, great, put it back till 5.
Yeah.
Wait a couple more years. But, extra children, a new house, a job, a promotion, all of those things are good opportunity. And I know
Mhm.
everybody has busy lives, right?
Yeah.
Um, last year, I mean, my own estate plan was out of date. Last year, I had everyone in my firm update their estate plans. So we remember what it's like to be a client and go through that process.
Mhm.
Um, and B, so it's less of a case of, the shoemaker's kids go barefoot, that type of situation.
Absolutely. Well, that has been very helpful. I want to spend just a few minutes asking a few questions from our Probate Help Desk Facebook community. And I have three or four. They don't all involve real estate, but if you're game, I'll just put them out there.
I'll do what I can. Remember, I cannot give legal advice.
Absolutely. So the first one is if someone is trying to settle, and I'm sorry, this topic comes up a lot outside of this question too, but the topic is credit card debt. So if someone's trying to set a credit card debt after a spouse's passing, what options do they have? And follow up on that, is using the proceeds from the sale of the home the only option?
There is no clear answer.
Uh-huh.
So I think is this a singular credit card debt? Is this a joint credit card? Who's had access to the credit cards? I mean, occasionally you see problems with someone continuing to charge on someone else's credit card.
Mm-hmm.
So there's not a uniform answer. In my book,
Yep,
there's
yep.
not. I do know that if you pay a credit card that is not yours, there's a possibility that you will have assumed liability for it. Now,
Interesting.
there is a place during the probate process when those debts of all kinds need to be dealt with.
Mm-hmm. What I really like about your answer is it really illustrates why we see so much debate on this topic online. Because this is a really hot topic in the probate groups, and you'll have some people advocating that that they don't pay the credit card at all. Others advocating that they negotiate with the credit card company. Other people, we get all of these variety of answers, but like you said, it really depends on the situation.
You know, I can tell you the sky is green and blue and orange, but
Right,
some days it is, you get the right sunset. But you know what? I can't give you general advice. Nobody can do that. Because unfortunately, everything is specific to your situation.
and that's why you didn't come right out and say it, but that's one of the reasons why me and other realtors in our network always recommend that someone talk to an attorney on matters like this, because in one case one solution might be great, but for your case it might not be. And it's so frustrating watching some of the clients um, spend dollars to save nickels. It's just it's just very
Probate can be very frustrating for people. It's not inexpensive.
right.
Again, good estate planning documents up front
Hmm.
are the better investment in my book. Also, you're dealing with emotions. Someone has passed away. Now we've got a sense of loss. We've got grieving. We've got creditors calling. We've got siblings wanting things the other ones want. Or siblings not wanting anything at all and landing it all on one sibling.
Hmm.
Preventing probate is your best option, quite honestly. But if you have to go through probate, I personally wouldn't want to go through it alone.
I
It's
wouldn't either.
it's a hard process. Again, it doesn't have to be. I mean, some of them go really easily,
Right.
and they just fall in place. But it's the ones that don't
Right.
that, you know, nobody's happy, right? The
Yes.
client's spending more money than they'd like to. You're trying to solve a problem that you didn't create, that was created before them, by a previous generation. So it's a challenge.
Hmm. Another question from our Facebook group. If someone, we'll apply this one to Minnesota. If someone in Minnesota has filed a small estate affidavit and they receive court notice saying all persons interested are cited to appear. If the person who filed is out of state, did they need to come back and appear for that hearing?
So in Minnesota, one of the best things that came out of COVID was they're all on Zoom.
Mm-hmm.
So if you get a
Just
court summons, you show up.
right.
But
Ab-
typically, it is a Zoom hearing.
Absolutely. That's a good point. In Minnesota, I know to your point, Minnesota still does the Zoom hearings. Now, one of the things I don't know in Minnesota, do people have the option to attend on Zoom or in person? And do they have to
I
notify
do
the court?
not, I do not know that, but
Oh, okay.
I have not been in anywhere it offered an in-person option.
Oh, okay. Interesting. Oh, right. Um, so I think the answer to that question is if you get something from the court, well, okay, I'm going to put a caveat on this. If I got something from court, I would share it with my attorney and then I would follow my attorney's advice. So I'm almost making the assumption in this case, maybe they're not working with an attorney, which is probably why we get so many of these questions. Um, one more from
And I
Facebook. Mhm.
understand if people want to do it themselves. So, there's, um, you know, the Minnesota judicial system has a self-help area within their website and
Absolutely. I'm going to actually veer off and go away from the Facebook question because you made me think about one of the questions that also pops up a lot. In Minnesota, if someone cannot, if they think they can't afford an attorney to go through probate, do they have other options to get legal help so that they don't have to go it alone? You mentioned the self-help center that the state has.
right. And they have some attorneys on call or some sort of, um, you can consult with someone.
Hmm.
I don't know the answer to that.
Okay,
If any of, I know several years ago I checked and there aren't many good options.
absolutely.
Whether legal aid or, um, volunteer lawyers or some of those types of things. I don't know what programs there are.
Yeah, I was just thinking of a person that I knew who was in Wisconsin. They were not in Minnesota, and I was not working with them, but they knew about some of the work that I do. And they had a multi-million-dollar estate in Wisconsin. And most of it was in real estate. It was a lot of it in real estate and then some in investment accounts. And they were trying to go through probate without an attorney. They didn't think that they themselves could afford it. And they ended up losing a lot of money um, in that process. And one of the options that was recommended to them was to consider taking out what do they call it, a loan against the estate to help pay for the attorney to save the rest of it.
Yeah, I
But
don't know.
yeah, but they declined, and it ended up being very costly
Yeah,
for
that's
them.
a shame.
Absolutely. Um, so Rebecca, before we close, are there any other tips that you would like to leave our families with?
I would say simply do your research.
Hmm.
Make sure the websites you're going to are like the Minnesota judicial system, ones that are, the Secretary of State, the Attorney General, ones that know the law and can better direct you if you're going that route. And they've got some pretty good explanations of things. The Minnesota Attorney General's website has some great info.
Absolutely. In fact, I look at that from time to time.
There you go.
It's and some of it's not pretty. Some of it's just very plain, black text on a white sheet of paper. But it's what they want you to do. It's right there in writing. It amazes me that more people don't look at that.
Yeah, I don't just think people don't know.
Yeah, that is true. And speaking of knowledge, on your website, one things you talk about, you really like to help educate people, give them information. You have a lot of great free resources available on your website. A lot of them are just blog posts and answer a lot of the questions we've been talking about today. Others, you have a free report. Is there anything you would like families to know about the free resources? I will put a link in our show notes, but anything you would like them to know about the free resources you have available on your website?
Again, ask questions. If you read something and you don't understand it, you can reach out. Again, educate yourself. Like you said, you go to the Attorney General's website because they've got good, solid information.
Absolutely.
So it's easy to want a quick fix, but sometimes that's a bigger problem. It's sort of, what do they say, penny wise and pound foolish.
Hmm.
So um, you have to be your own best advocate.
Absolutely. So I will put a link to your page and your contact information in the show notes. And again, I highly encourage families who are watching to go out and just check out some of the free resources that are available on your website. And again, we've been speaking with Minnesota attorney Rebecca Bell with RB Legal. And Rebecca, I really appreciate you coming on today and just sharing some tips and insights with some of the families in Minnesota and around the country.
Well, it's important. It's a mission to me to help people. You know, we're based in the Golden Valley, St. Louis Park area. We work in the 7 metro counties as well as throughout the state. Um, we sometimes have people say, I don't want my hometown lawyer to know all my business. So if they're in a small town,
Mm-hmm.
but no, I'm
Absolutely.
happy to help. Thanks, Maureen, for having me.
I really appreciate it, Rebecca. Thank you.